My comments here today will be brief, but I wanted to provide an update on the pending records request with the House, to which we received a response late last night, and then I'll be glad to answer any questions you might have. First, let me review the facts as we know them. On May 1st, the Senate Appropriations Committee obtained through a subpoena an email containing a web address, username, and password to a restricted site established for Special Agent Keith Schlib of the Office of Inspector General at the Social Security Administration. The site had previously contained the list of CCW holders, and access to this site was restricted to Agent Schlib. The following morning, May 2nd, a person or persons from a house IP address used this information to make repeated and unauthorized attempts to access this restricted site. This individual or individuals made a total of 23 unauthorized attempts to access this site with Agent Schlib's username in a 10-minute period. Our initial request that the House preserve relevant computer logs was first made to the House Clerk at 11:30 a.m. on May 2nd and was denied 6 hours later. Once that request was denied and I was concerned that the information would be destroyed, I issued an open records request under the Sunshine Law to the House Speaker, the House Clerk, and the House Chief Information Officer. As the agency charged with maintaining the security and integrity of the state's computer system, the Office of Administration has a duty to protect and safeguard information held on the state computer system. The request was straightforward and narrow in scope. Under the Sunshine Law, retain and provide the computer logs for a 1-hour period during which these unauthorized attempts were made. Late last night, House Clerk Adam Crumless issued a response identifying himself as the custodian of records for the purpose of the Sunshine Law and indicating the records have been preserved but will not be provided. The letter asserts a legislative exemption under Article 3, Section 19 of the Missouri Constitution. This arcane and rarely referenced provision states, senators and representatives shall, in all cases except treason, felony, or breach of the peace, be privileged from arrest during the session of the General Assembly and for the 15 days next before the commencement and after the termination of each session, and they shall not be questioned for any speech or debate in either house in any other place. They also assert that the records are closed under a provision contained in the Sunshine Law where, ironically, disclosure would allow unauthorized access to a computer system. The disclosure of the requested computer logs needed to identify who attempted to access a secure site on the state computer system would not jeopardize computer security for the House of Representatives. As we explained in our open records request, this information is a public record maintained by a public governmental body which the public and the press have a right to access. My interest is in protecting the integrity of our state's computer network, which this as yet unknown individual or individuals sought to undermine by using someone else's, a law enforcement official's, login information to gain access to a website restricted in this case to law enforcement purposes. Attempting to create a legislative exemption to the Sunshine Law or a misplaced reliance on a provision in the Sunshine Law in order to prevent the public from examining these records and identifying this person or persons is unsatisfactory and frankly troubling. Now that the House has designated a custodian of records and indicated that these records have in fact been retained, it is time for the House to provide them to the public. Again, these are open records and the public and the press have a right to access them so that the facts in this matter can be ascertained. Lastly, the response from the House of Representatives also included a Sunshine request directed to the Office of Administration. A response to those requests has already been sent to the House with responsive documents that were readily available, and the remainder of the request is being processed. And I'll be happy to answer a few questions.
Do you know, based off of the IP address, which specific office this attempt came from?
No, we do not, and that was one of the reasons why we wanted to obtain the request in the first place, was to obtain that information that the House has.
Would you be willing to honor a similar request for the IP traffic information of the Governor's Office, the Office of Administration?
They have in fact made that request of our office this morning, and the records we have available have been provided to them.
For many years.
What about to the press? Will you provide the complete IP traffic address of the Governor's Office and his staff?
If we have such a request, we'd be happy to review that.
Would you honor
There's
that
one.
request?
We'd have to review that request.
Okay.
What's the difference between your request to the legislature for that information and a request from the media?
We've not received any such request, so we'd be happy to review that.
Okay. For many years, whenever anyone's put a sunshine request to an individual legislator, it's always been denied because they've argued that individual legislators are not considered public governmental bodies under the sunshine law. Is that a problem that you've encountered in this situation? Are you willing to sue in order to challenge that?
Well, they have identified in regard to the response to our request, a custodian of records, which is the clerk. They've also indicated that they have a record, and they've responded to exemptions to both under the Constitution and the statute, that they don't have to provide this information. So in regard to that, I believe they do believe in this case that they have to respond under the sunshine law, although they are asserting exemptions that would not require them to.
What's the governmental role of the Office of Administration in seeking this information from a separate branch of government?
Yeah, my job as a commissioner of OA is to oversee government, or is to oversee the operations of government. And when we get information that pings our system, that someone is trying to use unauthorized access code to get into a site that for the previous 85 days had not been accessed, but was accessed the morning after the Senate Appropriation Committee released the email with the information, is a concern. And to maintain the integrity of the data that we handle for the state and its citizens, that's something that we are obligated to pursue and determine why it occurred.
You view this as an attempted hacking? Have you contacted law enforcement if they're trying to get into an unauthorized database?
Yeah, that's not my job, and I think that unauthorized access to this information is a concern, and that's for someone else in that role to make that determination.
You're confident you have the right location for that computer, that it was in fact in this building and a house office?
We are asking. That's exactly why we're asking for those records. They do have a wireless system. Our understanding is that it came from a house IP address, and that would be one of the things we would determine in regard to receiving that documentation if we could get it.
If the administration put an FTP site out there that created a vulnerability for outsiders to get access to restricted information, what difference does it make whether it's the House, whether it's a member of the news media, whether it's a political party? What difference does it make who tried to get into a site that this administration created and provided a password for an outside person to get into?
I'm glad you asked that question. In regard to the way this process works, that email was sent by one ITSD employee to a federal agent pursuing a lawful federal investigation. That information was provided to that individual on February 4th. On February 5th, that individual attempted to use that information and did not succeed in getting access to that site. No other attempts were made in regard to that site from that day until the day after the Senate Appropriation Committee chair released the email to the press and to the public, an email that was subpoenaed by that committee, by the Senate, to a federal officer that he complied with. How an unredacted copy got in the hands of these individuals is a question better asked the chair of the Senate Appropriation Committee.
Is it possible that I could have tried to access that information using the house Wi-Fi? And I'm asking a question because I know I didn't. But is it possible that anybody with access to that Wi-Fi system could be pinging that IP address?
That's a possibility, and that's why I think and we do not believe that to be the case, and certainly has not been represented to us to be the case. And that's exactly why these records need to be made public, to determine who did it, and why they did it, did they have the right to do it, and what impact, if any, did it have on the state system.
One regular recourse that the news media uses when they get unsatisfactory answers under the Sunshine Law is to file a lawsuit. Are you at the point of being ready to try this out in court as to whose rights to these records?
Government needs to be open and transparent. There's no doubt about that. You know, and the resolution here is really simple. You know, the speaker has indicated he knows who did this. He knows who gave him authority to do it. We've now, based on the response last night, have obtained acknowledgement that a record does exist. They need to produce the record and let the press and the public know who did it. And from there, you know, let's move on down the road. I mean, my job here is to run government. And, you know, I'm happy that the House has recognized that they have a custodian of records and that they understand that this record exists.
From a public policy standpoint, what difference does it make who got into a database the administration had put online, whether it's the House, whether it's a reporter, whether it's some political operative? Where does it make a difference to you in terms of, or your office or this administration, of assuring that in the future databases you have will not be accessible?
Yeah, that's the number one job we have in regard to our IT division, is protecting the integrity and security of our data. And to be rather direct on that, providing credentials to a law enforcement officer to do a legal law enforcement investigation and giving him access to that site does not allow others who obtain that information, that email, to then think that they have the right to access that site. There's a confidentiality statement on that email that indicates that if you are not the addressed user of that email, you should disregard and destroy that email. That was ignored. There's an exemption under the Sunshine Law that I think would have been applicable in this matter had the Senate Appropriation Committee elected to use that. They did not. That document was made public after that hearing pursuant to a subpoena the Senate issued. That is one of my concerns.
That law enforcement officer and his superior testified under oath to the Senate that that investigation never began. So should that website have ever been created?
I think what he testified to was it never got off the ground. He did make efforts to look at that information and from there did not move forward. When we get a request like this from a law enforcement officer, we honor that request pursuant to the provisions in the Revenue Law and the Driver's Privacy Protection Act, if it so applies, and I think in this case, yes, it should have been.
There have been those who have suggested that your sunshine request was laughable, I think was the word they used, because you guys created this database in the first place, and if it hadn't been created, you wouldn't have this problem now.
Well, as you are probably aware, the Driver's Privacy Protection Act, in the revenue statutes, we have thousands of these requests that come in a year. And these requests come in and they can be provided through a encrypted disk or the setup of an FTP secured site. And that is the key, secured site that goes to the individual who's been authorized to receive this information. This individual in this case was a federal officer doing a federal investigation. It was not anyone else who happened to come across that email and think it important to try to access it. It is also relevant, I believe, to understand that when this information is sent out, it's sent out to the individual with a user ID and a password. And as soon as that password is entered for the first time, it prompts that individual to change that password. And that is why the individuals attempting to use it with the house IP address were not successful.
And
Listen,
you
there's
said
some-
earlier,
the last question.
you said earlier that it really was not your responsibility, that if law enforcement took notice of this and wanted to look into it, that's fine. But I kind of wonder if you walked into your office and found that the door had been broken and your desk had been rifled, you'd probably call the Capitol Police to start investigating. This is kind of like somebody's looking through the drawers of state government. Why haven't you turned over to law enforcement and said, look and see if there's anything here?
Well, my job is not to determine whether or not a crime's been committed here. My job is to try to ascertain the documents to ensure the integrity of our computer system, and I can't even get that far.
But you do this if your drawers had been rifled in your desk. Why isn't this the same?
It's a different situation. It's a different situation. Thank you all.